Okay. So in the last class we have done with what? Everybody? We have done with? We have finished the kinds of offers and we have started essentials of offers and we have almost completed essentials of offers also. Yes or no? So let us just fast see the recap of everything that we have done. Okay. So what is a general offer? Any offer made to public at large is known as general offer. What is the case law for that? Supporting case law? Carlyle versus Carbolic, Smogball and Company. Another offer, another type of offer is next. Second type of specific offer or special offer. Okay. It is made to specific person or specific group of people. What is the case law for that? Bolton versus Jones. What is a cross offer? Making identical offers in ignorance of each other. That is cross offers. Okay, you are doing what? You're exchanging identical offers in ignorance of each other's offers. That is cross offer. What is the consequence of cross offer? What happens when there is a cross offer? No binding contract, no contract at all. You have only two offers, but you don't have any contract. Why? Because there is no offer and acceptance. There is only two offers. Okay. What is counter offer? Offer with modification, offer with, sorry, acceptance with modification, acceptance with variation is known as counter offer. So what is the consequence of counter offer? What happens when there is a counter offer? First thing that happens is immediately once the counter offer is made, original offer lapses. Now the choice, the acceptance is given to the person who has made original offer. Now he is the person who is going to accept the counter offer or reject the counter offer. Okay. What is standing or continuing or open offer? Which is, yes, which is allowed to be accepted over a period of time. Any number of time it can be accepted in that period of time. Okay, that is your standing or continuing or open offer. Now, what are the essential elements of valid offer? First essential element is what? It must be capable of creating legal relationship. Second one, certain, definite and not vague. Next, must be communicated to the offeree. What is the case law supporting this essential element? Lalvan Shukla versus Gauri Dutt. Next, made with a view to obtaining assent of the other party. May be conditional. Next, offer should not contain a term non-compliance of which would amount to acceptance. Offer may be specific or general. Offer may be express or implied. Next, I'll explain you. Okay. Offer is different from mere statement of intention. It is different from invitation to offer. It is different from mere communication of information. It is different from a prospectus, different from an advertisement. Offer is different and all these things are considered to be different. When any of these things happen, you cannot say that that is offer. Okay. Now, did we see this statement or intention or announcement? It is different. As I told you, I gave you the example of marriage. If you marry my daughter, I will transfer the property. That was just my intention. It was just my intention. I was just thinking about it, but I am not going to be bound by it. I don't want to get into any contract by it. Okay. Next, distinguish from just answer to a question. This we have seen in two case laws. Remember, Bumper Hall pen, two questions were asked. That is one thing. And MacPherson versus Apana, in that also owner property. for property, the person asked, what is the price at which you are willing to sell? That person said rupees 6,000. That was only the answer to the question, but it was not offer. Okay. Statement of price. Whenever you are specifying a price for something, it is not offer. Okay. That also Harvey versus Facey. Okay. Invitation to do business. Harris versus Nickerson. In this, Nickerson is the auctioneer who is going to just invite people to come and buy things. But can he withdraw the things which is put for sale? Yes. Anytime he can withdraw. He can withdraw and say that I wanted to sell, but now I don't want to sell. My wish. My property, my things, it is my wish. If I want to sell, I will sell. If I don't wish to sell, I will not sell. That was only invitation to do business, but that is not any offer. Okay. That also you understood, right? I explained you what is prospectus also. Remember? Now, offer should be distinguished from invitation to offer. Now, you tell me, what is invitation to offer? What is invitation to offer? Is it offer? Then it is just an invitation to get offers. It is not offer, it is just some person is having an idea of doing something, so he is inviting you to offer you. He is not giving you any offer. That is invitation to offer. I gave you one point, that is test to see whether it is offer or invitation to offer. How will you now know whether it is offer or invitation to offer? One statement is made. I want to sell you this. Or there is advertisement that I am advertising that in my shop there is stock clearance sale. Come and purchase goods from my shop. Okay. So all these statements, if you see, what should you see behind it to know whether it is offer or it is invitation to offer? So what should you see? What is the test for that? What is the test? What is the main point in that? Intention of the parties. The main thing that you have to see behind this is intention of the party. Intention of the party, who is making the statement, with what intention he is making. Say, if I am giving a statement to you, from that statement, immediately whatever I say, if you say yes, I will do that for you, it becomes a contract. Whatever I am telling you is an offer. But if my intention is, if I tell you something, I'm giving you one statement, but my intention it is that I will see what you say. I will see, and once you say something, then I will think about it, whether to do or not to do. Still, I'm not sure that I will do that thing for you. I'm thinking that I will think, I will bargain, I will negotiate, I will think to do or not to do. If that thing is there in my mind, then it is only invitation to offer, it is not offer. Intention to be bound by the statement immediately as soon as it is made, offer. Intention is to do something other, some further act, or intention to do some bargaining, intention to do some negotiating between the parties, then it is considered to be only invitation to offer. So this point clear? Yes or no? So this is very, very important that you have to see the difference between offer and invitation to offer. The main test is only this intention of the party who is making it. What is the intention behind making that statement? That you have to see. Okay. So we saw all these points. Okay. In these points, what did we see? Offer is what? When the intention is to immediately converting the intention into a contract. My intention, immediately I am making what? Contract. Then it is offer. But where I just want you to give me offer, I don't want to get into contract, but I want this person, I want everyone to give me offers, but I don't want to get into contract with anybody, then it is only invitation to offer. When there is an attempt to induce means what? To force someone to give you offers. You are making such statement that other person is getting attracted and giving you offers. That if there is a sale, if you give an advertisement, stock clearance sale, are customers getting attracted to it? They are getting attracted because of your statement. They're coming and telling, I will buy this, I will buy the shoes, I will buy the dresses, I will buy these clothes. So they are getting interested, they are getting attracted and coming and giving you offers. So what are you doing here? By that statement, stock clearance sale, you're just doing what? You're just inducing other person to give you offers. That is only invitation to offer. Okay. Invitation to offer is always precedent to offer. First, what will happen? Invitation to offer will happen. Then what will happen? Offer will happen. Then what will happen? Acceptance will happen. So always what happens? Invitation to offer is always before offer. It is always precedent. What is that you mean by precedent? Before. Something which is before. It is before offer. Acceptance of invitation to offer does not result in contract, but it results in what? Very good. It results in offer. Okay, acceptance of invitation to offer. If I tell you something, in return you give me something and I'm accepting it, then whatever you are giving is just an offer. So what happens? Accepting invitation to offer will give you what? Offer. Okay. The test would be what? Always intention with which the statement is made. Statement to be bound by it as soon as it is accepted, then it is offer. But statement is to do some further act before getting bound by it then it is invitation to offer. Now see the differences. This we did not see. From here we are going to start for today's class. Okay. Rest all we have already seen in the last class. Now from this understand this properly. Now meaning of offer. What is offer? Offer is defined in what? Subsection clause A of section 2. As per clause A of section 2, offer is what? Final expression of, see here they are changing some words so that they can make the comparison between offer and invitation to offer. So here actually this is not what is given in the definition. They just specified that it is given in clause A of section 2, but whatever is given down is not the definition. They are just giving the explanation to the definition. Okay. So final expression of willingness of offer to be bound by the offer should the other party choose to accept it. If I tell you something, you are accepting it, what happens immediately? Contract. I am getting bound by it. I now have to sell you the car. I now have to sell you the house. I don't have any other choice. I cannot think twice now. Then it is what? Offer. Okay. Invitation to offer is what? Without expressing final willingness. That is not my final willingness. Once I am telling you something, you tell me something, then I'll think again. That is not final whatever I am telling you. I need some more time to think again. Okay. That is what? That is only invitation to offer. So proposes certain term on which he is willing to negotiate. Where I am telling that say for example, I'll just give you one example before starting this. You will clear your intermediate. Once you clear your intermediate, what will happen? You will go to college or not? Graduation college. Yes or no? So now for graduation, doing your graduation, you wanted to get enrolled in any college, a good college. So in the college, that college, there is an advertisement given that there is this college and there is the advertisement given, admissions have started. What is the advertisement? Admissions started. Now what will you do? Once you see this, you want to get enrolled in this college. Once you see this, what will you do? You will go to this college and what you will do? You will take the application form for this getting enrolled in this college. Yes or no, everybody? Will you do this? Yes or no? Now in this application form, there are so many details that you have to give. One of the details will be marks code. Yes or no? Marks code in your intermediate 1, intermediate 2 and the aggregate of everything all will be there. Okay. Say you have scored 80% of marks. So application form, you will fill the application form and this application form what you will do? You will submit this to the college. Yes or no? Will you not do that? Now the college will get so many application forms. Now what will happen? They will decide the cutoff. Very reputed college, but they are having seats only 100 seats. And the applications they got is 500. Can they give admissions to all 500 students? Is it possible? They will decide cutoff, and the cutoff that they have decided is 90% of marks. What was the cutoff? This is the cutoff. The student who gets 90% and above will get the admission. Students who gets 90% and less will not get the admission. Now, what will happen to your application form? Will it be accepted or rejected? Will it be accepted or rejected? Rejected. So when the college gave this advertisement, admission started, come and take admission in our college, was that offer or invitation to offer? Invitation to offer. Why? Because if you say yes, if you file the application form, are they getting bound by it that they have to give you admission, or they want to think whether they want to give you admission or not? They still want to think whether they want to give you admission or not. They want to still negotiate. We will give you or will not give you marks. Will give you or will not give you admission. They still have to think that. So always when they don't want to get bound by any statement, that statement is always considered to be what? Invitation to offer. I just hope you have understood now properly what is invitation to offer and what is offer. Everybody, yes or no? So I gave you 3 examples if you remember. I gave you example of departmental store, DMart and all, where things are displayed, that is only invitation to offer. You go and pick up things, that is offer. And when the cashier gives you the bill, that is acceptance. While giving you the bill, while making the bill, can he reject any item? Yes, he can reject. Got this point clear? So that is example for offer and invitation to offer, the difference. Another example which I gave you of was prospectus, if you remember. Yes or no? Company issuing prospectus, what will happen? They will get applications from the members. Those applications, can it be rejected also? Yes, it depends on the company. They can accept or they can reject. Yes or no? So prospectus is what? Invitation to offer. Applications are what? Offer. And giving allotment of shares is what? Acceptance. Same with this college admission. Advertisement, admissions are open is what? Invitation to offer. Okay. Then application form, taking application form, students taking application is students taking application form is what here? Offer. And then acceptance of application form is what? Acceptance. Clear with this? Please write the example in your own words. Okay. You need to learn these examples, then only you'll understand the difference. Otherwise, you'll not understand anything. Let me make this very clear to you. Done? Yes or no? Okay. Now let us come to the differences again. So what is offer? Offer is final expression of willingness by the offerer. See here, many places offer and OR there is a gap given. There should not be any gap. Okay, so correct that. Many places that is only what is happening, so you will get confused. That is not offer or, that is offerer. Okay, correct that. Okay, many places you will see that, but seeing the context of the sentence you will understand that it is not offer or, it is offerer. Okay, so willingness by the offerer to be bound by the offer should the comma should the other party choose to accept it. Okay, where a party without expressing his final willingness proposes certain terms on which he is willing to negotiate. He's just telling you some terms where he now wants to bargain more, do some further act. That is not offer, that is only going to be what? Invitation to offer. If a person has intention to be bound by the terms as soon as the other accepts, he is making offer. A person has intention of negotiating the terms means he is only giving invitation to offer. Sequence. Offer cannot be precedent to invitation to offer. That means offer will be always subsequent to, after. Subsequent means what? After invitation to offer. But invitation to offer will always be what? Precedent to offer. Before offer, invitation to offer. Clear? Okay. Now you understood the difference between offer and invitation to offer, everybody? Yes or no? Okay. Next. So we are done with this topic, offer, types of offer and essential elements of valid offer. Now in our essentials to valid contract, we have seen one essential element where we have seen there should be valid offer as well as there should be valid acceptance also. We now know when the offer will be valid offer. All essential elements that we have discussed, if present in offer, then valid offer. Same way, there are some essential elements to be present in acceptance also. Then only it will be valid acceptance for your contract. If those essential elements or any one essential element is missing in the acceptance, then it is not valid acceptance. You have valid offer but you don't have valid acceptance. Can there be valid contract? No. Valid offer plus valid acceptance will make valid contract. Clear? Okay. Now, in which section acceptance is defined? Clause B of section 2. As per that, what is the definition? When the person to whom proposal is made signifies his assent thereto, proposal is said to be accepted. Accepted proposal becomes a promise. So this clause B of section 2 is for acceptance also, is for promise also. Okay. Now, there is just a relationship which was made between offer and acceptance, and that relationship is given by Sir William Anson. Sir William Anson showed you a relationship that is present between offer and acceptance, and with what it is compared? Acceptance to offer is what a lighted matchstick to a train of gunpowder. See, what is a train of gunpowder? It is a type of material which is inert, which is inactive, which is not having any properties within itself. But when this train of gunpowder, there is any person lights fire to it, there is a explode. There is explode. What happens in wherever area that gunpowder is present, and you lit fire to it, then there will be explode. Fire explode. Okay, that will happen there. So same way how it is compared, now I'll just tell you this. Train of gunpowder is there. There is this train of gunpowder, okay, and there is lighted matchstick. When these both combine together, train of gunpowder is getting, lighted matchstick is coming to this train of gunpowder, then what will happen? There will be a explode. Yes or no? Same way, this Sir William Anson has compared offer and acceptance to this train of gunpowder and lighted matchstick. He said, train of gunpowder is your offer. It is inactive. Offer is made, it is offer. It is having nothing, no property is nothing, offer. But when this offer is combined with acceptance, what will happen immediately? What will happen immediately? Contract comes into existence. When this acceptance touches offer, what happens? Contract comes into existence. Once, just now I told you, when the proposal accepted always becomes what? Promise. It becomes a promise. And in law, when I told you, normally you promise, you break promises. Normal life, day to day life, you do that. But in law, can you do that? No. When something becomes a promise, you have to perform your promise. You cannot say a no. Now, can you say that no, no, I will not perform my promise, or this person, whoever have given acceptance, can he say, I will not perform for what I have agreed? Can he say that? No. Whatever offerer has said, he will have to agree to it. Whatever this offeree or acceptor has said, he will have to do it. Now they cannot say a no. Once what happens? Once the acceptance touches offer, now can it be reversed again? Can it be reversed? Can offer be offer, acceptance be acceptance? No. It is not separate now. It has now become a contract. Same way, once the lighted matchstick touches train of gunpowder, there is an explode. Everything is gone now. Can you get that train of gunpowder again? No. Can you separate the train of gunpowder and lighted matchstick? No. Then finish. It is over. Same thing will happen here also. You cannot again withdraw it. You cannot now say, no, no, I promise that I will give you car. I don't want to give you car now. Can you say that once it is accepted? No. Once it became a contract, no one can do anything. You have to do it. If you don't want to do it, then bear the consequence. Bear the punishments. Whatever is the punishment, you have to bear that. Got this point clear? Yes or no? So got the relationship between this now? Whatever Sir William Anson has said? Okay, just we'll read this once again. Okay. So relationship between offer and acceptance was given by whom? Sir William Anson. According to him, acceptance is to offer what? A lighted matchstick is to a train of gunpowder. This means as soon as the train of gunpowder is lighted, it would explode. Train of gunpowder is what here? Offer, which is in itself inert. Inert is nothing but something which is inactive. Something which cannot do anything alone. That is inert. Singly, it cannot do anything, but in combination, it will become active. So, inert is something which is inactive. So, train of gunpowder in itself is inert, but it is the lighted matchstick which causes the gunpowder to explode. The significance of this is an offer in itself cannot create any legal relationship. Can it create any legal relationship? Offer alone? No. But it is the acceptance by the offeree which creates the legal relationship. Once an offer is accepted, it becomes a promise and cannot be withdrawn or revoked. To revoke something is to withdraw something, that is to take back something. Okay, that is nothing but to take back. An offer becomes a contract as soon as it is accepted. Understood with this, everybody? See, these kind of questions, these are reasoning questions. How you'll get this? Acceptance is to offer what a lighted matchstick is to train of gunpowder. Explain. Statement will be given and explain will be given. You have to give the explanation, show the relationship. Okay, so that is how you have to give the answer for that. Now, let us come to essential elements of a valid acceptance. The first one. Audible? Audible? देखो आप, आ रहा? Okay. So let us start with legal rules regarding a valid acceptance. Essential legal rules here is nothing but your essential elements of a valid acceptance which are required to be present in acceptance to make it a valid acceptance. First one, acceptance can be given only by the person to whom it is made. Okay, it can be given only by the person to whom it is made, but not any other person. Do you remember I gave you an example? If any person happens to hear conversation of two people and he is giving the acceptance, will it be valid? No, it can be accepted only by the person to whom it is made. Okay, so that is nothing but Bolton versus Jones is the example. Again, you have remember the of yes, offer was given to whom? Proclehurst. But acceptance was given by whom? Bolton. So what did Jones do? Jones have cancelled the contract saying that you are not the person to whom I have given the offer. How can you accept my offer? The offer should be accepted only by Bolton or no one else. Yes or no? So same thing, same case law is taken here. But there is one exception to this rule. There is one exception, and that exception is exception. You know what is that you mean by exception? Exception is something, there is a general rule. Now, in further topics, you will understand exception more properly. Exception is nothing but there will be a general rule which will be applicable to all cases. But there are few cases to which it will not be applicable, and those few cases are known as what? Exceptions. Okay, general rule is that it can be accepted only to the person to whom it is made, but only in case of general offer, it can be accepted by anybody. Anyone can accept it. Okay, okay. एक बार देखना स्टक हो गई कि नहीं चल रहा ना? पेन क्लिक करो या कुछ क्लिक करो, नहीं चल रहा। चार्जिंग है। हम्म। Hmm. Okay. So what is this what is the general rule? That acceptance should be given only by the person to whom it is made. But this general rule is having one exception, that is nothing but your general offer. In general offer, it can be accepted by anybody, everybody, by public at large, it can be accepted. Okay. Next. That is nothing but the general rule, the case law supporting general rule is what? Carlyle versus Carbolic, Smokeball and Company. Next, acceptance must be absolute and unqualified. What is that you mean by this term? In offer, we have seen one of the essential element which is telling us offer may be conditional. That means it may be conditional or it may be unconditional also. But here they are saying acceptance must be absolute, clear and unqualified. Here means what? Always it should be unconditional only. If you attach any conditions with acceptance, then is it acceptance? It, what will it become then? Counter offer. It is no more acceptance, it will become counter offer. Understood? Yes or no? So acceptance must always be absolute in clear terms, that is, and unqualified means always it should be unconditional only and expressed in usual and reasonable manner. Expressed in usual and reasonable manner means what? See, sometimes what happens, whenever I'm giving you offer, I'm telling you I will sell my house to you at 20 lakh rupees. If you want to accept, please write a letter and give me. So how you should give the acceptance, that also I mentioned in my offer. Can I do that? Can offer be conditional? Yes. I am giving you offer and I'm putting a condition that if you want to say a yes to my offer, then what is that you have to do? Write a letter and say a yes to me. Then you have to only write a letter and say a yes. You cannot use any other modes. There are various modes of acceptance, nothing but various modes of communication. You can call me and tell me that you have accepted. You can message me, mail me, fax me, or write a letter to me. Come to my house and tell me, yes, yes, I accept. There's so many modes of communication. But if any mode of communication is prescribed, then you have to follow that mode only. But if nothing is prescribed, then nothing. You just said that I want to sell you my house at 20 lakh rupees. Then you can use any mode. Any mode means what mode? Usual and reasonable. You cannot go to the terrace and shout, yes, yes, I give the acceptance. That is not usual mode. Okay? Yes. Okay? So that is the reason you have to use something which is reasonable, which normal people, normal thinking people uses. Don't use something which is unusual. Okay? Clear with this? That is what law is saying. Law is saying if prescribed, follow prescribed. Nothing prescribed, then usual and reasonable mode you have to follow. See now, sometimes what happens, I am telling you that I will sell you my house for 20 lakh rupees. Okay? And I told you that write a letter and tell me. But what did you do? Instead of writing a letter, you called me. Called me and told me that, yes, yes, I accept. Now, it is my wish. I can say, I told you to write a letter. Why didn't you write a letter? I will not sell your house. Or I can say, okay, no problem. I am okay with telephonic acceptance also. I will sell your house. Now when it is prescribed, you have to follow prescribed only. But once you don't follow the prescribed, then you cannot force the acceptance on me. There will not be contract. It is now my decision. Why? Because this will again become what? Counter offer. Variations in the terms of offer. You have changed my terms of offer. You have varied my terms of offer. Therefore, now decision is my decision. Clear with this, everybody? Yes or no? Did you understand? So that is what is given here. Acceptance must be absolute and unqualified. Now the case law here is Neil versus Merritt. Neil versus Merritt. In this case, what happened? In Neil versus Merritt, Merritt offered to sell land. Merritt offered to sell land to Neil. I want to sell you my land at 280 pounds. I want to sell you my land at 280 pounds. Now Neil said, gave the acceptance. Who gave the acceptance? Neil gave the acceptance saying that yes, yes, I will purchase your land at 280 pounds, but I will give down payment, down payment of 80 pounds through a check. Immediately I will give you only how much? 80 pounds, and remaining amount, whatever is remaining, how much is remaining now? Remaining is how much? 200 pounds. I will give you in 5 monthly installments. 5 monthly installments. But here, when Merritt gave this offer, he wanted the payment at once. I will give you the land, you give me the payment. But what did Neil do? Neil said, I will purchase land, but the payment I will make in this way. Now, you tell me, can Merritt cancel this contract? Cancel this acceptance? Why? Because the acceptance is qualified acceptance, and in our essential element, what did we discuss? Always the acceptance should be how? Always the acceptance should be unqualified. But in this case, acceptance is qualified. That is nothing but it is conditional acceptance. Therefore, in this case, what happened? Merritt said, I will not sell you the land. They went to court of law, and court decided in whose favor? Court decided in the favor of Merritt. Saying that that was the counter offer. Now Merritt will decide whether he wants to sell you the land or not. Why? Because the acceptance made was not absolute and unqualified. It was a qualified and conditional acceptance, which is not considered to be valid to form a contract. That was the case. Next case law is Union. You want to write this? Please write. Please write. You also write that court decided in the favor of Merritt because the acceptance given by Neil was the qualified one, which is not considered to be valid acceptance for a contract. So this is the conclusion which is to be written after every answer. Whatever is the main point, that is considered to be always the conclusion part, which you have to give. That is decision of the court. Okay. Clear? Done? Done with making a note? Okay. Next case law is Union of India versus Bahulal. Here, Union of India is coming why? Because this contract was between a person Bahulal and some government authority. Okay, Bahulal was selling his property to some government authorities. Okay, this in connection with government. That is the reason Union of India is going to fight this case. Okay. Now, in this case, what happened? This person, Bahulal, had a property which he offered to Union of India at rupees 1 lakh. How much? At rupees 1 lakh. Now, Union of India told, yes, yes, we will purchase your property. They gave the acceptance saying that we will purchase the property but not at 1 lakh but at rupees 80,000. We will purchase your property not at 1 lakh but 80,000. Now, what did Bahulal said? I will not sell you the property. I wanted to sell the property at 1 lakh. Now you did not accept at 1 lakh. Now I don't want to sell you the property. Union of India went to court of law. Now you will get a doubt. Union of India and court are one and the same. Do you think that? Anybody? They are two different parties. Yes or no? See, government and courts are two different parties. Anyone can file a case against government also. Court is someone who is not related to anybody. Okay, they are unbiased. They are not biased with anybody. That you are government, so we will support you. No, they are unbiased. Whatever is truth, they will support the truth. Okay, their main purpose is to just give the justice. Whatever is right, they are going to support right. Okay, but you know what? One thing I wanted to tell you: whenever you see some court cases in movies and all, you see a statue with a black color band. You know why it is like that? अंधा कानून क्यों बोलते पता है? क्यों बोलते? Very good, very good. This is the case. This is the point. They only give the decisions based on evidences. आप proofs दो, वो लोग decision देंगे. आपके proofs सही है, गलत है, they'll not see that. You give the evidence. See, I am the person who is right. You are the person who is wrong. But I tried to find evidence, but I did not get any evidence. But you made some wrong evidence against me. They will give judgment in favor of the party. So what happens generally, they see only evidence. Obviously, they cannot know what is happening, yes or no. Did they go to the situation and saw the situation? No. So they will only see the evidences. Evidences produced, good evidences produced, proper evidences produced, finish. It will be decided in your case, in your favor. That is the reason sometimes what happen wrong, the person who is innocent person will also get punished because of this. That is the reason Andha Kanun. Okay? Clear? Okay. Anyways, but mostly you have many, see, they will investigate into the case. They have people who will investigate. They're big lawyers. So they will try to get the right only. Their main aim is to do what? Give justice to innocent person only. Most of the cases that will happen. But sometimes, yes, wrong people will also get favored. Okay. Sometimes. Okay. Anyways. So let us get to the topic once again, okay? So Union of India versus Bahulal. So in this case, what happened? Bahulal gave the offer, I will sell you my property, my land at 1 lakh rupees. But Union of India said, I will purchase but only at 80,000 rupees. Now Bahulal said, I will not sell you the property only. Union of India went to court of law, filed the case. There is a contract. He is now required to sell me the property. He is not selling the property. Now you tell me in whose favor court will decide? Bahulal's favor, that there was counter offer and the decision is whose decision? Bahula's decision. Now it is his decision either to accept or to reject. Whatever Union of India did was the qualified acceptance, therefore it was not valid acceptance. This is not valid. So in this case also, as a conclusion point, you can write court will decide in the favor of Bahulal as Union of India gave qualified acceptance, which is not considered to be valid acceptance to form a contract. Clear? Done? Finish? Okay. Now, the next one. Acceptance must be communicated. We have seen this in the definition again. What is the definition of acceptance? The person to whom proposal is made signifies his assent thereto, then he is said to accept the proposal. Yes or no? Signifies here means what again? Communicated. So, signifies which is given in the definition itself. So, obviously, acceptance need to be communicated. Communication should always be in some perceptible form, means some acceptable form. Just now, as I told you, it should be in some form which is usual and reasonable form, not something which is unreasonable. It should be something which is acceptable. Any conditional acceptance is no acceptance, as it is a counter proposal and has to be accepted by the proposer. Counter proposal, counter offers will be always accepted by the offerer only. Yes or no? Why? Because counter proposal is given by always the acceptor. Acceptor it will be given and it should be accepted or rejected by the proposer, offerer, if the original proposal has to materialize into the contract. The offeree must have knowledge of the offer made to him, otherwise there will not be any acceptance. So clearly what is given here? Clearly they are saying that if I want to tell you something, if I want to say give you offer, I will give you offer. Offer should be communicated, that we have seen in essential elements of offer. But in acceptance also what is being told, if you want to say a yes, you have to communicate. The communication can be express or implied here also. Express means what? In words, either oral or written. Implied means what? Actions. You can nod, you can give a thumbs up, or you can do some actions which will show that you have accepted. But if you do nothing, neither expressed nor implied, you just stand. I'm asking you, will you purchase my car? You're just standing and looking at me. Can I understand that you will purchase or not? Can I understand your acceptance? Can I read what is going into your mind? Obviously not. So it has to be communicated to the offerer. Who will have to communicate this? The offeree will have to communicate the acceptance to the offerer. Who is offerer? Who is giving the proposal? Offer. Who is offeree? To whom the offer is given. The person to whom the offer is given is the offeree. Once that offeree is accepting the offer, he becomes the acceptor. Clear with this? Yes or no? Okay. Now, case law. Brogden versus Metropolitan Railway Company. Metropolitan Railway Company. Now, in this case, what happened? Brogden gave an offer to Metropolitan Railway Company saying that I will supply coal to you. What I will do? I will supply coal to you for your railways. To run the railways, I will supply coal to you. And he gave all the terms and conditions in that offer letter. Everything was given and it was given to the manager of this company. It was given to the manager of Metropolitan Railway Company. It was given. Now, manager got this offer letter. Okay. In this offer letter, he read everything. Manager read everything. Then he applied the stamp of approved on it. What did he apply? The stamp of approved. Yes, we are accepting this offer. After applying the stamp, he put the offer letter in his drawer. There was drawer where he put the offer letter, thinking that this offer letter I will have to give to my legal team so that they can make acceptance letter also. Acceptance letter will be made by a legal team which is to be given to now Brogden. Offer letter is given by Brogden. Now again acceptance letter will be given by Metropolitan Railway Company to Brogden. So for that, what did he do? He told that he just kept it in the drawer so that it is to be given to the legal team. So this was kept in the drawer to be given to the legal team. But he forgot to give this to the legal team. It was still in the drawer. But actually, if you see, Brogden gave the offer. Was that offer accepted? It was accepted. Actually, they wanted coal from Brogden only. But was that acceptance communicated? No, it was not communicated. Then this company said, went to court of law, filed a case saying that, see, we have gave we wanted the coal from this Brogden, but he did not supply the coal. Is Brogden bound to give the coal to the company? No, because there is no communication, there is no acceptance, there is no contract. Clear with this, everybody? Yes or no? So that was the case. So from this case, it is decided that always there should be communication of acceptance. If acceptance is there in your mind, whatever the person offering thinks, that is immaterial. You must be thinking in your mind, I want to accept, I want to accept. But if you're not communicating that acceptance, then it is of no use. If you want to accept, please communicate it. Either expressly or impliedly you communicate it, then only it is going to be valid contract. Clear? Yes or no? Another case law is Bhagwan Das versus Bhagwan Das versus Girdhari Lal. Bhagwan Das had a cotton plant. Say he is a person who is supplier of cotton seeds. He is the supplier of cotton seeds at the place Ahmedabad. Ahmedabad, his place of business is Ahmedabad. Now, what is he doing? He is offering Gindhari Lal that I have cotton seeds and I am going to supply cotton seeds to you. I am going to supply cotton seeds to you. Gindhari Lal is having a cotton mill, which is at Khamgaon. Which is at Khamgaon. Okay. Now what happened? There was a contract which was entered, but Bhagwan Das did not supply the cotton mill. Sorry, the cotton seeds were not supplied by Bhagwan Das. Now, in this case was not something which is related to actually communication. This case is what you know. What is the place where contract is considered to be taking place? Hmm, I'll tell you why. To Ahmedabad. Why? Because why it is required for you to know place of contract? So sometimes place of contract, समझो I am in Hyderabad, you are in Hyderabad, we are entering into contract. Obviously, place of contract is Hyderabad. But there is a confusion in the place of contract only when two parties are at different places and they are entering into contract. Now Bhagwan Das is at Gujarat, Ahmedabad, and Girdhari Lal at Khamgaon, and now they will think whether the contract is taking place in Ahmedabad or contract is taking place in Khamgaon. Why place is required to be very? Why place is very important? Why? Because contract is entered, but if something wrong happens in the contract, there is some dispute that happens in this contract, then which jurisdiction which jurisdiction which jurisdiction should they go now? Should they go to court at Ahmedabad or should they go to court at Khamgaon? And they should go only to the court, only that court where the contract took place. So here what is being said, that the place where acceptance is made, where the place where acceptance is made, sorry, the place where acceptance is given, that is the place where the contract comes into existence. So here in this case, offer is given where? Khamgaon. Sorry, offer is given where? Ahmedabad. Offer is given by the person in Ahmedabad actually. An offer is given actually to a person in Khamgaon. But acceptance is given by the person in Khamgaon to a person in Ahmedabad. So when contract comes into existence? Only when Bhagwan Das receives the acceptance. Yes or no? Only when he receives the acceptance, then only contract comes into existence. If say this Bhagwan Das is not aware whether acceptance is made or not, yes or no, I don't know, will contract comes into existence? No. He should know. Say Bhagwan Das is telling Girdhari Lal that I will sell you. So it should reach the other party or not? It should be communicated means what? Reach the other party. Acceptance also, should it reach the other party? Yes. So where did it reach? It has reached Ahmedabad. So Ahmedabad is the place where the jurisdiction is there to take care of the case. If any disputes happen, then at which court, which place you will go? Ahmedabad. Courts in Ahmedabad, there you will go, because that was the place where the acceptance have reached. There was the place where final contract came into existence. Here, that was only the case law all about. That is Ahmedabad. Now, see, you will get, I told you this, okay, write this case law, then I'll just general point I'm telling you. First, write. You write this properly, the sentence. Which court has the jurisdiction to entertain the case? Which jurisdiction means what? Right. Which court is having the right to accept the case? Which court? Ahmedabad court. Okay. So this case law is to know this only. Which court is having the jurisdiction? For this, it is important to know the place of contract. The place of contract is the place where acceptance have received, acceptance have reached. Clear with this? Yes or no? So that was this case law. Now in this case you tell me, done, finish, everybody. Okay. Now you tell me Girdhari Lal, who filed the case here in this case? Girdhari Lal filed the case. You remember I told you whenever there's a case law, how it will be. That is the reason there is a confusion. That is the reason I'm telling you this point. What happens, case is filed. Case is filed by Girdhari Lal. Against whom? Bhagwan Das, saying that this person did not supply me the cotton seeds. Okay. In that case, who is the plaintiff? Plaintiff is Girdhari Lal, and Bhagwan Das is whom? Defendant. But I told you in the case, generally first will be plaintiff and second will be the defendant. But here if you see, the name of defendant is coming here and the name of plaintiff is coming second. Why? Why? Because sometimes what happens, there is decision given by the court. District court gave the decision. They are not satisfied with the decision of district court. Then again they will go to higher courts. Now here in this case, there was a decision given by one of the court, and decision was given in the favor of Girdhari Lal, saying that okay, Girdhari Lal is right. Now the compensation penalty is to be given by Bhagwan Das to Girdhari Lal. But Bhagwan Das, did he accept it? No, no, I will not pay any penalty. I will go to higher court. Now again he is going to higher court. Now who is filing the complaint in higher court? Bhagwan Das. That is the reason name of Bhagwan Das is coming here. So Bhagwan Das, when you're going to higher court and when you're filing a complaint in higher court, the first party is known as appellant. When you go to higher court, the first party is appellant, and the second party, the name second party is respondent. Appellant means what? Again I am appealing, please refer the case. Again, respondent is what? Answering to that appeal. Okay. Plaintiff is what? The person to whom something wrong has done. He will fight the case. Defendant is what? Who will defend the case. Okay. Then higher court, again you are filing. The person who is filing is appellant. The person who is responding is respondent. Okay. Just for you, nothing will be asked. Just so that when you see the cases, you will get it out. Okay, ma'am said plaintiff should come here, defendant should come here. Why defendant is coming first? Why? Because now that defendant has become appellant. That is the reason in higher court his name is coming first here. Understood, everybody? If anyone did not understand also, it is okay. Don't understand. Why? Because this is something which is not very important. Okay? But if you want to understand, you can ask me. That is, I will explain you 100 times. Not a problem. Okay? Okay. So understood this case law? Yes or no? Hayworth versus Knight. This is not very important case. So I'll just tell you what it is. In this case law, what happened? There was one offer given. Okay, offer was given. See, there were into say some shipping business where there were some goods cargo was to be shipped at one place and the person was shipping using that shipping facility, something like that it was. Okay. So in this case what happened, there was a party who uh, gave an offer with some terms and condition that these are the goods which I want to ship, and this is the price, this will be the discount, and this will be the expenses which you will bear. Everything was given, terms and conditions of the offer was given. Acceptance, the person to whom this offer was given, again that person gave acceptance. Acceptance was also given in this legal terms only, with all terms and conditions it was accepted. See, in this case what happened, same terms and conditions were there. Offer had same terms and conditions, acceptance also had same terms and conditions, but there was only difference of language. There was only difference of language. Now what happened, the offerer changed the mind. Offerer did not want to sell or did not want to ship the goods. So there was a change of mind. Now he did not want to do, but contract came into existence. He did not want to bear any punishments also. I gave you offer, you gave me acceptance, contract came into existence. Here he did not want to bear any punishment, but he did not want to perform his part in the contract, offerer. So what did he do? He went to court of law and said that I gave this person offer, this person accepted with changes in the terms. Therefore, there is modification, variation in the terms of acceptance, and therefore it is a counter offer. Now he gave me counter offer. I want to do what? I want to reject the counter offer. But there was mischief in his mind. It was not a counter offer. It was normal acceptance. There was just change of language. He went to court of law saying that obviously court, they are mental people. Can't they understand that there is only change in language? Everything is same. They understood that and they decided in the favor of acceptor, saying that you have to perform the contract. So from this actually, Hayworth Knight, there was a point which was satisfied that mere change in terms of offer, sorry, mere change in language, sorry, just change this, mere change in language of offer without change in terms, without change in terms will not make it a qualified accept. It is not a qualified acceptance, but it is very much a valid acceptance where contract came into existence. Why? Because there was only mere change in the language, but there was no change in the terms of the contract, which was contended by the offerer actually, but the court gave the decision in the favor of acceptor. Wait a second, actually. This point only I'll tell you properly so that you can make a note. Point is being missed. Why? Because if the question comes, then as a conclusion, you have to give this point. This point is important. So make a note of this point properly. Write down. Now write down the material, top of the material, or somewhere you have place, you can write down. Okay. Just put an arrow mark. Hayworth versus Knight के पास. You write down this. Whatever now I'm dictating you. A mere variation in the language mere, mere, mere means simple, normal. Mere variation, a mere variation in the language, mere variation in the language, not involving, not involving, not involving, just 1.5 line, not too much, not involving any difference, not involving any difference, not involving any difference in substance, not involving any difference in substance, would not, would not, would not make the acceptance, would not make the acceptance, would not make the acceptance ineffective, would not make the acceptance ineffective. This is in legal terms. Whatever we have written here, this is same thing in simple terms. No change in substance means what? No change in the terms. There is no change in the terms, but there is only change in the language, which is not going to make your acceptance ineffective. Acceptance is very much valid. Clear? Yes or no? Understood this point? Everybody? Acceptance must be in a prescribed mode. We already discussed this. Prescribed mode means what? Prescribed by the Offerer, prescribed by the offerer. I am giving you offer, I will prescribe how acceptance is required to be made. Either by telephone, letter, or come to my house and tell yes. Otherwise, I'll not accept it. Anything I can say, you have to do it. If you don't do it, then it is my choice. I will reject or I will accept. Okay. So it should be in prescribed mode. And if nothing is prescribed, then usual and reasonable mode. Which is usual and reasonable, accepted by everybody. Something which is, don't do something which is unusual. Okay. Okay. Time. Acceptance should always be within the specified time. Specified time means what here? The offerer gave you a time. He gave you a time saying that if you want to accept, then accept in 5 days, 10 days, 1 week, 2 days. You have to give the acceptance. If you don't give the acceptance, then it will be rejected. My offer will lapse over. See, for example, say what happens. X told Y, I will sell you 100 bags of wheat. I will sell you 100 bags of wheat. You pay me 10,000 rupees for that 100 bags of wheat. This was the offer given. But he said that if you want to buy bags of wheat from me, then you have to say yes or no in 5 days. How many days you have to accept? So you have to accept in 5 days. If you are not giving the acceptance in 5 days, then what will happen to my offer? My offer will automatically lapse, come to an end. That means what? On sixth day, what is Y doing? On sixth day, Y is coming to X and telling, yes, yes, I will purchase your 100 bags of wheat. Then what will X do? I already sold. Go from here. I already sold the bags of wheat to some other person. Or he will say, I have the bags of wheat, but I don't want to sell it to you. Can he say that? Yes, he can always say that. Yes or no? Why? Because whatever offer was given by him, it was only valid till how many days? 5 days. After expiry of fifth day, the offer automatically lapses. That means it comes to an, clear with this everybody? Yes or no? Now this example, this type of example we have seen in that point. You remember? Offer should not contain a term non-compliance of which would amount to acceptance. But in that case, what happened? This offerer said, if you don't say a yes in 5 days, then I will assume that you have accepted. Now you will have to purchase that bags of wheat from me. Yes or no? Those type of offers are obviously not valid. So don't get confused between both the examples. This example is for the time limit and that was for the that point, non-compliance of the term. Clear? Yes or no? Everybody, please don't get confused. Okay? Now, okay, specified time limit. You have seen sometimes what happens. I will give you offer. I will sell you my house for 20 lakh rupees, but I did not specify any time. If I don't specify any time, then what is law saying? It should be within reasonable time. It should be always within reasonable time. Reasonable time and before offer lapses. Reasonable time is nowhere defined in the Act. Reasonable time is nothing but it depends on facts and circumstances of the case. Facts and circumstances of the case. What is a reasonable time is not defined in the Act. 1 year, 1 month, 1 week, 5 days, 10 days, no time is given that this time should be reasonable time. No time limit is given. It always depends on the facts and circumstances of the case. Say, for example, A and B entered into contract. A said that I will sell you 10 liters of milk. I will sell you 10 liters of milk and you pay me 1000 rupees for that 10 liters of milk. 1000 rupees for that 10 liters of milk you sell me. Sorry, you pay me. Now in this case, there was no time limit mentioned. But A did not give the acceptance for 1 day, 2 day, 3 days. Do you think that milk will remain good for 3, 4 days, a week, 10 days? It is what type of good? It is a perishable, which is only good for a day. Yes or no? So you have to give acceptance within few hours or within a day. Yes or no? After that, if you give the acceptance, will it be valid? No. In this case, though the time limit is not given, but the facts and circumstances of the case are such where you will know the time limit. Okay, within this time only it should be given. After that time, if I say yes, then A can always reject my acceptance. Why? Because my offer will lapse. Reasonable time is over. Specified time is not available, but reasonable time is over. It is coming to an end. Understood? Or it can be said instead of that, I will sell you 100 oranges. Okay, I will sell you 100 oranges, you give me 1000 rupees. In this case also, what is this type of good? Perishable. If you don't give acceptance for 3 days, 4 days, 5 days, 5 days, will that oranges be in good condition? Obviously not. Why will he keep those oranges for you? He will sell it to some other person. Why? Because it will damage, it will deteriorate. Yes or no? Clear with this? So always the when time is not specified, it will depend on the reasonable time. Reasonable time is nothing but depending on facts and circumstances of the case. Perishable time depending on that type of good. Say I told you before also some electronic good also, before that item becomes outdated. Why? Because you know how technology changes. Now you have something, in few months or few weeks, again you have a new version of it. Again you will have a new version of it. So whatever you're selling within few weeks or few months, if you don't say a yes, then it will become outdated. It will not be available for you. Not perishable. It is something which is changing rapidly, but not something which is going to damage or which is going to get spoiled. Perishable goods generally eatables only. For eatables only, they are perishable. Perishable is something where for some time it will be good, after some time it will not be available only. But in technology it will become outdated. It is available but no one wants to use it. Why? Because you have new technology now. It is like that. Okay. But there are few people who want to stick to old technology also, they may use. Okay. Here with this? Yes or no? Okay. So that is the time limit. Now, next one. Mere silence is not acceptance. Mere silence is not acceptance. Here again means what? Mere silence means what? Acceptance should be communicated. If you are keeping silence, though you want to accept it, but you're not saying anything, it is not considered to be acceptance. In your mind, you have accepted. You have said a yes, but did you communicate? You kept silence. It is not considered to be acceptance. The same thing is given. So here the case law is Feldhaus versus Bindley. Feldhaus versus Bindley. Feldhaus versus Bindley. In this case, what happened? Feldhaus was, say, he is uncle of, say, Mr. A, some person, Mr. A, who is having horses. Who is having horses here? Mr. A is having many horses. That horses are being auctioned. All the horses are being auctioned. Now, to do this auction, Mr. A appointed Bindley. Mr. A appointed Bindley as the auctioneer. Remember who is the auctioneer? Agent of the seller. So who is the owner of the horses actually? Mr. A. And who is the person who is conducting auction? Bindley. He is just the auctioneer. That is nothing but agent of the. He is the agent of the person Mr. A. Okay. Now what happened? Feldhaus wrote a letter. He wrote a letter to Mr. A, saying that a particular house, a particular horse, say white color horse, his name was something. That horse I want to purchase. Please don't auction that horse. Keep that horse aside for me. Who said? Feldhaus, who was uncle of Mr. A. Understood? So he wrote a letter to whom? He wrote the letter to Mr. A. So that was an offer by Feldhaus. He was giving the offer. I want to purchase that horse at this much price. Please keep that horse aside. Please don't auction that horse. He came to know all the horses are being auctioned, but he had some work, so he couldn't attend the auction. That is the reason he was uncle. He was related to Mr. A. He told beforehand only, you keep that horse aside for me. Now, what did Mr. A do? Mr. A read the letter and Mr. A told Binley that horse to keep aside for my uncle. So here, one offer was given by Feldhaus. Was that offer accepted by Mr. A? It was accepted. He actually wanted to sell that horse to uncle. Did he also communicate it to Binley? He told Binley auctioneer also that that horse I want to sell it to my uncle. Keep it aside. But due to negligence, because Binley forgot, he sold that horse also in auction. That horse which was to be kept aside for uncle, that was also sold by Binley to some buyer, some purchaser. Okay, who has bid higher price, that person got the horse. Now, Feldhaus came to know about that. Feldhaus came to know about that, and Feldhaus said to Binley, now I will file a case against you for conversion of my property. Why he's saying that is my property? Why is saying that horse is my property? Why? Because though there was no communication between Mr. A and Feldhaus, but uncle assumed that he is my nephew. Why will he deny? He will always say a yes. I know he will say a yes. I know he will keep it aside for me. And actually, that only happened. But was there any communication? There was only communication between Feldhaus and Mr. A and Mr. A and Binley. Did Mr. A again gave the acceptance to Feldhaus? There was no acceptance here. Who kept silence here? Mr. A kept silence. He did not say anything. Conversion of property means what? You have converted my horse into cash. Now you gave the horse, and in return of horse, what did you get? You got money. So you converted my property. Now you pay me damages. You give me that cash also, plus you give me compensation also. Who said that? Feldhaus said to Binley. Got this point clear? But in this case, the court decided in the favor of Binley, saying that there is no contract which was formally entered between Mr. A and Feldhaus. But in this case, if you see this case, don't you think there is something wrong done by Binley here? It is only because of his negligence, his carelessness this happened. So should he be punished actually? Yes. But how that punishment should be? That punishment should be only between Mr. A and Binley. Feldhaus is having no right to get anything from Binley. Who can claim compensation? Only Mr. A. Mr. A can say that I appointed you as my agent. You should listen to my instructions. Did you listen to my instructions? No. So I will not give you salary. I will not give you commission. I had to give you commission of 10,000 rupees. I will not give you only 5,000 commission. That all things will happen between whom? Binley and Mr. A. But Feldhaus, is he having any right to get anything from Binley? No. So in this case, the court decided in the favor of Binley, saying that Binley is not liable to Feldhaus. He is not liable to pay anything to Feldhaus. There was no case filed by Mr. A against Binley. So obviously there is no question of getting any compensation, nothing. But Feldhaus, will he get anything? No. There was no formal contract entered. There was offer, but was there any acceptance? No. Why? Because there was the party offeree who kept silence. He did not speak anything, he did not communicate anything, therefore there was no contract. Clear? Yes or no? The facts of the case I'll tell you, just make a note of facts of the case properly. F, just write F. Okay. F offered to buy. F offered to buy. F offered to buy. बाई बोल तो खरीदना. BUI. ये स्टेटमेंट के कॉन्टेक्स्ट में BY भी आता. F offered to buy his nephew's horse. His nephew's horse. His nephew's horse at 30 pounds. At 30 pounds. At 30 pounds. Saying, how did he give the offer? Saying, if I hear, in inverted commas you write. Why? Because this is the statement given by uncle. Inverted commas. ऐसे inverted commas डालकर लिखो. If I hear no more about it, if I hear no more about it, if I hear no more about it, I shall consider the horse mine at £30. I shall consider the horse mine at £30. Close the inverted commas. Close the inverted commas. Horse mine. Hmm. Hmm. Then the horse is not sold to anyone. Then what happens, you're asking? I'll tell you. Then it will always obviously be uncle's. Yeah. He was ready. Yes, both the parties were ready. Uncle wanted to buy and nephew wanted to sell also. But what happened here? Horse is no more available, but there was no proper acceptance given. Therefore, there's no contract. Otherwise, the nephew did not reply to F. The nephew did not reply to F. The nephew did not reply to F. But, put a comma and write but told auctioneer, but told auctioneer, but told auctioneer to keep particular horse, to keep particular horse, to keep particular horse out of sale. To keep particular horse out of sale. Full stop. By mistake, the auctioneer sold the horse. By mistake, the auctioneer sold the horse. Full stop. F, F, F is nothing but Feldhaus. Sued means going and filing a case. The word sued means going and filing a case against any person. F sued him for conversion of his property. F sued him for conversion of his property. Full stop. Held means nothing but this was the decision of the case. Held, comma, held. F could not succeed. F could not succeed as his nephew had not communicated the acceptance to him. Had not communicated the acceptance to him. Had not communicated the acceptance to him. Clear? Understood? Everybody, the case law? Let it be. Monsoon is going on. No, this will happen. Concentrate. Okay? Next, acceptance by conduct or implied acceptance. What does this mean? Inactions. Here they mean that acceptance by conduct, implied acceptance is very much valid. Express, acceptable. If it is implied also, acceptable. But there has to be some type of acceptance. Either express or implied, it is acceptable. Okay, that is what is given here. So as per section 8 of the act, when a person performs act intended by the proposer as a consideration for promise offered by him, the performance of the act constitutes acceptance. So sometimes what happens, if I tell you, I want you to sell me 100 kgs of sugar. I want you to sell me 100 kgs of sugar. You did not say anything to me, but what did you do? You delivered sugar at my place. Your actions are telling that you have accepted. Though you did not communicate, but you communicated how? By delivering sugar to me. Delivery of sugar is nothing but here acceptance by, that is nothing but your implied acceptance, which is very much valid. Clear? But sometimes what happens, the offerer will say, you have to expressly also accept. Then you have to expressly accept and then do the action. Nothing is stated in the offer, terms of offer, then implied is also very much valid. If it is stated, then you have to expressly accept first, then do the actions. Clear with this? Everybody? Yes or no? Okay. So now we are done with this topic, acceptance and various essential elements, that is legal rules regarding acceptance. Understood everybody? See, we have seen so many case laws. If you see, you have to understand the case laws properly. Sit down. Okay? Don't pack up your bag. Sit. Now I'm just giving you the introduction for communication of offer and acceptance. We have seen acceptance. We have seen what happened? What happened? Come on. We are still, we have time, okay? Hmm. I'll take 6 minutes. Don't worry. Or I'll take 10 minutes also. हाँ? नहीं है ना? देखो. चलो अब 15 मिनट्स भी ले सकते हैं, है ना? नो आई अंडरस्टैंड. जनरली थियोरी सब्जेक्ट्स में क्या होता है, एक टाइम लिमिट रहता है जिसके बाद इट विल गेट वेरी मोनोटोन. जितना भी अच्छा रहे दो सब्जेक्ट, थियोरी सब्जेक्ट में इट हैपेंस. आई आल्सो गॉन थ्रू योर स्टेज, नो, सो आई नो दैट. बट till time or 5 minutes extra, it is okay, but not more than that. Okay, anyways, I'm just giving you brief introduction, so don't worry. Anyways, we started 5 minutes late, no, so we can take 5 minutes also. That will be same time. Okay, communication of offer and acceptance. Now, till now we have seen what is offer and what are the legal rules of offer, what is acceptance and what are legal rules of acceptance. Do you remember both the legal rules we have seen? Offer should be communicated, acceptance should be communicated. So it is very, very important for a contract that there should be effective communication of offer, effective communication of acceptance. Here, what is that you mean by communication? Communication here means offerer is communicating offer so that it is understood by the offeree. Offeree is going to communicate acceptance so that his acceptance is being understood by the offerer. Yes or no? Then only it is considered to be effective. See, if communication is not proper, then don't you think there will be a lot of misunderstandings? There will be a lot of disputes between the parties? Yes. In future that will happen. Then they will run to court of law. So to avoid that, it is better that when you form a contract, it is always better that you communicate the terms between the parties properly. So there has to be always effective communication. So effective and proper communication prevents avoidable revocation and misunderstanding. Revocation is what? Nothing but withdrawal of offer and acceptance. You are taking back. I gave you offer, no, I don't want to do it. You said you gave me the acceptance, but now you don't want to accept. So what are you doing? Something which is given, taken back, that is known as revocation. Understood? Something which is given and again taken back, that is known as your revocation. Withdrawing something, taking back something is revocation. So it will avoid your revocations and misunderstandings if there is only proper and effective communication. See, now if you see, when parties are face to face, You are standing in front of me. I am the shopkeeper. You want to come to my place and buy some pens. You are saying, I want to buy 10 pens. Tell me how much it costs. I am telling you, you take these 10 pens, you give me 100 rupees. You are giving me 100 rupees. Done. Contract is over. So the communication will not be difficult when parties are face to face. Face to face, it is clear. And if there is any misunderstanding or there is confusion also, immediately we'll sort that out. Okay, I didn't understood. Okay, you tell me which type of pen you want. Okay, you will ask, okay, don't you have some pen which is of lesser price or some pen which is of higher price? So if there is any confusion, we will clear up the confusion face to face itself. Yes or no? So it is very easy when the parties are face to face. The difficulty arises only when the parties are at two different places. They are distant to each other. They are not at same place. They are not face to face. Only then the problem arises for communication of offer and acceptance. I want to tell you something, but say using the telephonic conversation or writing a letter, I am telling you something, you are understanding something else. So that can happen when the parties are far from each other, distant to each other. So that is the reason you should know when communication is proper, when communication is considered to be complete. For this point clear? Yes or no? So when parties are face to face, there is instantaneous communication. What is that you mean by instantaneous? Instantaneous means immediate. Immediate communication. Immediate. Immediately it will happen communication. There is no time limit here. I will say you something which my wish and you will say yes or no to my wish. Then finish. Instantaneously it will happen. Instantaneous communication of offer and acceptance. In such case, the question of revocation does not arise. Once I give you offer, you give me acceptance. Offer acceptance happened. Valid offer, valid acceptance. What came into existence here? Contract. Now can I take back? Once contract comes into existence, we have seen, remember, train of gunpowder and lighted matchstick. Once it happens, can you again take back? No. Once contract comes into existence, you cannot withdraw, you cannot take back, you cannot come to your original terms. Done, finished. It has happened now. You have to do it. I will have to perform, you will also have to perform the promises. No one can do anything. So in face to face, that is the case. I am giving you offer, you are saying yes, contract came into existence. So there is no question of revocation happening here. Okay. So does not arise since offer and its acceptance is made instantly, immediately, instantly it is going to be. The difficulty arises when contracting parties are at distance from one another and they utilize the services of post office or telephone or email. These are the various means of communication which you use to communicate offer and communicate acceptance. So when you use any of these means, then only the problem arises. When you are face to face speaking to each other, no problem arises. Here the problem arises. In such cases, it is very relevant for us to know exact time when offer or acceptance is made or complete. When it is complete. Why? Because once offer is given, it reaches the other party, then only the communication is complete. Yes or no? Then only you can give me acceptance when once offer reaches you. What is the time when it has reached? What is the time when it is when the offer is considered to be complete? What is the time when communication of offer is complete? That you should know what should be the time. And once you give me the acceptance, what is the time when acceptance, communication of acceptance is complete? So it is very, very important to know when the communication of offer is complete, when the communication of acceptance is complete. So now time of communication of offer and acceptance that we are going to see in the next. You have to concentrate properly. Why? Because it is a bit confusing. For all other various means of communication, time of completion is different. Telephonic it is different. Face to face it is different. Postal services it is different. So you have to understand those properly. Clear? Type of questions will be direct questions can be asked. Directly they'll say what are the various modes of communication, or they'll say when the communication of offer and acceptance is complete, then you should say as per section 4 of the Act, the Indian Contract Act 1872, you have to write the answer. Whatever is given, the communication. Or they can give you a case. Say how the case is given. All the relevant points you have to give. All the points only related to communication, right? Yes. It will be just two to three paragraphs. Two paragraphs maybe. Only two paragraphs you have to write. For 5 to 6 marks answer, you have to write at least two paragraphs, half of the page or three-fourth of the page. You have to write that much, right? Yes or no? Or any case can be given. Mr. A posted the letter. Mr. B got the letter this time. So they'll ask you when communication of offer is complete. Case, no. In this case, there is no case law. In this case, there is section. As per section 4, so communication of offer is complete at this time. So for in the given case, the communication of offer will be complete for Mr. A at this time, Mr. B at this time. Likewise, you have to write. First, write the main answer, the section you have to write. Then correlate the section and the given case. That will be the answer. Okay. Anyways, as you write the exams, you will come to know how to. Law presentation is very, very important. You have to present answer properly. Case law is given 3 paragraphs. Answer. First paragraph will be the main answer. Second will be correlation between the case and the main answer. And third will be the conclusion. Just 2 lines or 1 line conclusion. Therefore, not entire thing, only relation. Mr. A did this, Mr. B did this, therefore the court will give the decision in the favor of Mr. A. Likewise, as per say what do you say, Carlyle versus Carbolic Smoke Ball and Company, some case comes where instead of giving the name Carlyle, they'll say Mrs. Leela or some name, whatever it is, or the company they'll say XYZ company, something they'll say. Okay, so same case law, facts will be same, that the person made some medicine which is to be consumed. Same case they'll give, but some facts will be changed, but decision will be same. So that what you have to do, as per the decision given in Carlyle versus Carbolic Limited, this was the decision that general offer can be accepted by anyone from public and the contract comes into existence. In the given case, now you should say, in the given case, the offer given by XYZ company was same as given by Carbolic company, which was a general offer. Therefore, Mrs. A accepted, and the court will give the decision in the favor of Mrs. Z, and there is a contract where XYZ company will have to give the compensation, that is pounds, whatever it is, 100 rupees, 1000 rupees. In the case, it will be given that they have to give compensation of 1000 rupees to Mrs. A. Therefore, you have to say general offer made to general public is very much valid. So, likewise, you have to give the answer. First the main answer, then correlation of the given case, then the conclusion part. Anyways, you will come to know. Once you write 2-3 exams, then you will understand how to give the answers. Nothing difficult. Once you are thorough with the subject, you know the topics thoroughly, you can give the answers. See, only definitions are the things where you should not make any changes. Definitions as it is. Remaining all part you can write in your own words. Understanding is important. You understand, and that understanding you write in your own words. That is important. That is enough. Definitions, not in your own words. Please don't make your own definitions. Definitions you have to stick to only definitions given by the Act. Okay, that is very important. Remaining, it is not at all difficult, so don't worry about it. Clear? Done? Shall we stop for today now? Yes or no? So let us end for today. Now we'll continue in the next class. Okay?